Chapter 28, Part 2. Okay, so the Congress was not satisfied with what the outcome of the 1933 Securities and Exchange Act did, wanted to put more meat into it, make it more than just a disclosure law, so they enacted the Securities and Exchange Act of 1934, which provides for the regulation and registration of security exchanges, brokers, dealers, and national security associations. I've bolded the second part here because that's the primary emphasis of the Act of 1934. The 1934 Act provides for continuous periodic disclosures by publicly held corporations to enable the SEC to regulate subsequent trading. It's more of a fraud statute than a disclosure statute. The Act also authorizes the SEC to engage in market surveillance to deter undesirable market practices such as fraud, market manipulation, and misrepresentation. The Act also provides for the SEC's regulation of proxy solicitations for voting. Okay, so Section 10B, or SEC Rule 10b-5, deals with insider trading and prohibits the use of any manipulative or deceptive device or contrivance in violation of SEC rules and regulations, prohibits fraud in connection with the purchase or sale of a security, and it applies to all cases concerning security trading or exchanges over the counter or private. It allows private parties to sue for securities fraud under Rule 10b-5. The basic elements of those are a material misrepresentation or omission in connection with the purchase and sale of securities, scienter, which means goes to intent or wrongful state of mind by the seller, reliance by the plaintiff on the material misrepresentation, an economic loss by the plaintiff, and causation. That is a causal connection between the misrepresentation and the loss. Okay, insider trading. The goal of 10b and 10b-5 is to prevent the purchase or sale of securities on the basis of information that is not available to the public. So there's basically two types of problems that exist. One is where somebody is within the corporation and learns about something within the corporation that's going to affect the value of the stock on the stock market, either up or down. So if the stock is likely to go up because of something that's happening within the corporation, for example, a new product that's going to make a lot of money, they can't profit from that by buying stock at today's price and then selling it later after that news becomes public. Or they cannot prevent themselves from losing money on stock that they own where the news is not going to be helpful to the corporation and lead to a lower selling price and therefore dump their stock. For that situation, generally, it's almost a strict liability type of thing where if it occurs within a certain number of days, and we'll get to a slide on that, they have to cough up their profits or other remedies. The other is where the information is leaked by an insider to somebody outside who then profits from that. The classic example of that was Martha Stewart, who, and in case you're not aware of that, what happened in that was that there was a drug company. She knew the CEO of the drug company. The drug company was about to market a drug for cancer that would be very profitable. However, they got a letter from the Food and Drug Administration saying that the drug was not being approved because of some reason. He told Martha Stewart. Martha Stewart dumped all the stock that she had in that before it became public, and therefore saved herself a great loss. She was prosecuted and went to jail for that. Much to, I guess, her chagrin, had she held on to the stock, a few months later, the Food and Drug Administration actually approved that drug. It went on sale, and the stock went up. So had she ignored what she had been told by this insider, she would have saved herself jail time and made a profit. All right, so any material omission or misrepresentation in connection with the sale or purchase of a security may violate 10b of the SEC. Examples of material facts calling for disclosure: fraudulent trading in the company's stock by a broker-dealer, a dividend change, a contract for the sale of corporate assets, a new discovery, a new process, or a new product, like the drug, a significant change in the firm's financial condition, and potential litigation against the company. Tip-E theory: anyone who acquires inside information as a result of a corporate insider's breach of fiduciary duty can be liable. And this extends to tip-Es. Those are the people who receive tips, and even remote tip-Es. That is somebody who has been tipped by the tip-E. Okay. It is irrelevant whether the insider actually uses the inside information. Now we're dealing strictly with insiders, as I said before. We call that short swing profits. Any short swing profits that are made by an insider during that period of time is considered to be short swing profit that has to be returned to the corporation. And it applies to stocks, warrants, options, and securities. Okay. The Private Securities Litigation Reform Act, the disclosure requirements of Rule 10b-5 deterred the disclosure of forward-looking information. To solve the problem and promote full disclosure, Congress passed the Private Securities Litigation Reform Act. Okay, so the penalties for the 1934 Act for a 10b or a 10b-5 violation, a person can be fined up to $5 million, $25 million for a partnership or corporation, and face up to 20 years in prison. Under the Sarbanes-Oxley Act, a violator can face up to 25 years in addition to being fined for a willful violation of the 1934 Act. Civil sanctions: both the SEC and private parties can bring actions against the violators for insider trading, and securities fraud. The violation must occur through the use of a national securities exchange or a broker or dealer. Private parties may bring in action for violations of 10b and 10b-5. That completes Part 2 of Chapter 28. The magic word for Chapter 28 is Ponzi, which we'll be getting into in Part 3.